When you read a case, you're looking for what they call the IRAC method, which is issue, rule, analysis, and conclusion. So you have a case, and you read court opinions, and those are Supreme Court opinions or higher court opinions. You read the facts of what happened, and you find out what the problem was. The issues are narrowly tailored, so there might be one specific issue, 2 or 3 or whatever in a case, but they're not, because it's on appeal, not everything's on appeal, just issues. So you have to look for the issue, then you have to look for the rule, and then they analyze that. They analyze the facts, rule, and the issue. So that's the analysis part. And that's the part that professors ask you about. And that's a part that sometimes we don't analyze as well because we got a lot of cases to do this for. So anyway, and then you just give them the conclusion, which the conclusion is really not as important. We already know with the rule what the conclusion is going to be. So you don't have an outline like in college, where we can study down a type of outline and subject matter and all that. You study by rules, and the tricky part of it is when you learn how to read a case, and then you're like, oh my God, I picked out the rule. When you were in law school, you get really good at about just kind of like skimming through, and then you're like, okay, this is the issue, and then okay, here's the rule, because you know how they start wording things. But you're doing that all the time. As a lawyer now, I don't do that as much, so I really have to go back and read the case really, really well. But when you're a student, that's all you do. So you can skim, and I used to do that. You can skim through the facts, like, okay, rule, okay, here's the issue, you highlight that, and you keep reading, okay, here's the rule. But in a case, it doesn't tell you, here's the issue, here's the rule. No, you have to figure that out. So once you do that, you have the analysis, and sometimes you feel really good about finding the rule, and all of a sudden, you're like, okay, great, this is awesome, I found the rule. All of a sudden, you keep on going, the next cases you're supposed to study, there's an exception to that rule, and then exception to that rule, and then another exception, so you're like, typically what you have to do in your own notes, and they do sell outlines, but that's not how they teach you, because you need to do the analysis. So typically you'll have, okay, breach of contract, there has to be an offer and acceptance. Exception, if they didn't confirm or they didn't, they just keep on putting exceptions. So you have your main rule, and then you have exceptions, and sometimes you have exceptions to those exceptions. So that's how law school is, and that's called the Socratic method.